And hello.
And are we on?
We are.
We are on. Okay. Hello, everybody. This is Zachary Lawrence of Parkside Property Management. Welcome to the 20 plus years broadcast of Landlord Tenant Radio. Everybody knows the guy on my left, on my right. It would be your left, my right. Just want to make sure that everybody knows who we're talking about. We're talking about my friend Dennis Block. He's an eviction attorney. He's an expert in the field, and he is offering 30 minutes of his valuable time to share a discussion on the topic he knows much about, and that is the landlord-tenant relationship. Dennis, before we get to that, tell me a little something about your upcoming trade show at the Long Beach Convention Center on May the 15th.
May 15th, we're going to have a big seminar for landlords. We're going to be talking about, unfortunately, the spread of rent control. I've been kind of ringing the bell on this topic, that legislation is looming which might allow many municipalities to institute rent control. So come, it's going to be free, and my seminar starts at 9 o'clock in the morning. That's the Long Beach Convention Center.
That's 9 o'clock Western time for those listening in New York, by the way.
Oh, please. But in any event, come on out, and really we need to do some proactive work in terms of protecting your property interests, because if the municipalities such as Long Beach, which are threatening to institute rent control, you're going to need to be prepared.
Well, Dennis, that's interesting, but a little bit vague. When you say if your municipality institutes rent control, and if you have a building that is currently not under rent control, you have to be prepared. You left me hanging there. You left millions of people hanging there. What does that mean, prepared?
Well, my good friend, you're going to have to come out to the seminar.
Okay, but give us a flavor of what you're going to be talking about without giving away the game plan. Just give me a little bit of a hint what you're going to be talking about.
A little bit of the hint in terms of what you're going to need to do to prepare is to make sure that you have your rents up to market level, and do that now, and also that you, even if you do have tenants that are at market level, that if you do have any malcontents, some bad tenants in the unit, you're going to need to terminate their tenancies. But I don't want to go into too much, because May 15th, 9 o'clock in the morning, please come out to the Long Beach Convention Center. It's free. If you have property in non-rent controlled areas that you're leasing, this is going to be a very, very important seminar for you to attend. Also, even if you have rent control property, there's going to be some laws that might even affect to the detriment of rent control landlords.
Like what?
Well, they might be doing away with something called Vacancy Decontrol, where you might not be able to raise rent even if a tenant voluntarily vacates. So we're going to go over all the strategies, what you need to do, and really it's going to be a really, really important event, and I hope everybody is there.
Okay, Dennis, you used the word malcontent. Now, I'm assuming that you're not talking about me personally.
Well, sometimes.
Sometimes, okay. But assuming that you mentioned a malcontent tenant, apparently you know what that is, but for our listeners out there, what exactly is a malcontent tenant?
It's a person who's not an easygoing person, who's always making demands on the landlord. There's always many, many more things wrong with his unit.
High maintenance.
Yeah, high maintenance. And sometimes you have a person who has poor housekeeping skills, or you have a person who sometimes just creates disturbances. Not every day, because obviously you could always terminate the tenancy, but it's enough where it's always on your mind about this person. That's my definition of a malcontent. They pay their rent,
right,
but this is not someone that you'd want remaining in your building. And if you think about it, once rent control is instituted, and I sincerely believe, unfortunately, that it will be instituted in many, many municipalities all up and down the state of California, you're going to be stuck with this person. And it's not going to be enough to evict unless you have good cause, and that's not necessarily going to be considered good cause. Right now, if you have a month-to-month tenancy, you don't need any reason to evict. You just issue a 30 or a 60-day notice to quit.
In a non-rent controlled jurisdiction.
In a non-rent controlled jurisdiction.
Okay, Dennis, assuming that you have a malcontent tenant in a rent control jurisdiction, we have one. I get emails daily saying we had to call the police. She was blasting her stereo at 11 o'clock at night constantly. Then she stepped out of her unit, starts cursing at us. And this is more than one of the tenants in the same building. And we get these complaints about her over and over again. The police have been dispatched to the property, and basically she falls under this category of malcontent. For our landlords out there that do have a malcontent tenant in a rent control building, given the facts that I just gave you, that the police have been dispatched, what tools are available to get rid of this tenant?
Well, I think this is above a malcontent. This is true nuisance behavior, and this would not be a difficult case to bring forth, even in a rent-controlled area. You are gonna need the assistance of other tenants who would be willing to come to court and testify. That can be done. You can always subpoena tenants. You can get them to write letters, but then we can always force them to come to court. But we are going to need the assistance of other tenants in the building. But based on the conduct that you're describing, we do have a case for eviction. That's a nuisance tenant.
Excuse me, Dennis, how often are tenants willing to take that extra step and not only send me an email saying we had to call the police, but A, file a police report, and B, willingly go to court to support this eviction?
It's usually a mixed bag as to whether tenants will come to court or not. Sometimes you get them chomping at the bit. Yes, I want to go. I'll be the first one there. I'll drive you to the court. But in many cases, you have a situation where the tenants, number one, don't want to be bothered, or that there's a fear of retribution, so that they're not going to want to go. But if you can get me a couple of tenants that can come to court, then that usually is a good case for eviction. Also, what we can do is we usually have the tenants who are unwilling to go to court. We say, okay, just write us a letter. So they'll write us a letter with regard to the conduct of the tenant and how they've been bothered and harassed by this tenant. And then what we do is we subpoena that tenant to come to court. And of course, once we have them on the stand and we show them the letter, they're going to have to tell the truth. So we do use many, many ways to accomplish this. But if you've got true nuisance behavior, that is a case for eviction. Today, for example, I took in a case where a person who was ex-military, I don't know what kind of mental problems he's having, but in the last 6 months, he's literally flooded his bathroom at least 5 different occasions. And in the last month, he caused fires on the stove where literally the fire department had to come twice. And of course, the landlord, the case I just took in today, asked me whether that's grounds for an eviction, and I'm saying of course it's grounds for eviction. I mean, this is the definition of nuisance behavior, where you're potentially creating a situation where life and property could be terminated based on his behavior. So if you've got people like that, obviously that's a clear case for eviction, rent control, non-rent control. But what I'm referring to with the malcontents is the one who's calling you up every day, sending you letters. And as I talk to my clients on that, in a rent-controlled area, that's just considered free speech. They're allowed to ask you to fix something, even if it's minor, like a crack in a wall plate or something. Or they'll be sending you letters regarding any kind of issues dealing with that the air conditioning doesn't work well, the heating isn't well. And this is the only person in the building who's complaining. That's a malcontent. And those cases you cannot bring forth in an unlawful detainer action in a rent-controlled area. Non-rent control, you don't need a reason. And so that's some of the things that I'm talking about, not just to look in terms of that your rents are up to market value, but that you're also taking an affirmative act with regard to getting rid of these malcontents.
Mm-hmm. Dennis, you mentioned subpoenaing a tenant. Issuing a subpoena to a reluctant tenant to support an eviction case. Would a police report be a satisfactory substitute for having a tenant appear in court saying such and such happened?
Yeah, and I get this question all the time, and a police report is zero evidence. It means absolutely nothing. It means that all that happened was that the incident occurred, the police were called, all the conduct is already passed, and the police are there to retake a report. The police aren't the witnesses.
Excuse me, but does not the police report memorialize the events for the reasons that they were there?
in any event, that report is considered hearsay. So unless you have the police to testify as to their personal knowledge, it doesn't really work well in a court of law to prove your case.
Are you saying the police report is inadmissible?
A police report's inadmissible. If you
inadmissible.
Inadmissible in and of itself. If you had the police officer there, then he could testify as to that police report, and then that could be introduced into evidence. But then again, if the police officer's there, you're just going to ask him what his perception was as to what occurred on the property. You know, he came up and he saw the guy with a baseball bat over another tenant's head. That's a great witness. But quite frankly, what you want is when the police get there, everybody's already run and been quiet, and they're taking the statements of the people. Well, that's hearsay. It's a statement out of court, and you need to actually have that person attend the hearing.
Okay, Dennis, let's go back to Evidence 101 in law school. Hearsay is an out-of-court statement offered for the truth of the matter asserted.
That is correct.
Okay, now, there are exceptions to the hearsay rule, and one of them is a document or a statement may be entered into court as evidence if the probative value outweighs the prejudicial effect. Now, if you're in court with a police report, would that not act as a satisfactory exception to the hearsay law?
It would not.
It would not.
You'd have no way of authenticating that document. You'd have to have
Here it is, Your Honor. Here's the policeman's signature. Here's the report number.
And the judge is going to say, I don't know that that's the police officer's signature. You need to authenticate the document. So that would not be entered into.
So your message to the landlords is that if you have a police report, stop salivating that it's a slam dunk that you can take that report, go to court, and throw out your tenant.
Correct. You need to have witnesses to the conduct.
Okay.
And also, part of what the statute is in rent-controlled areas, such as Los Angeles, is that you have to prove that you're creating an unreasonable interference with the comfort, safety, and enjoyment of the premises to other residents. So on that basis, how do I prove that their comfort, safety, and enjoyment was interfered with if I don't have that person in court to prove it? So the fact that the police were there, that's of interest, and you can use that in a kind of peripheral sense. But with regard to the actual proving of your case, I need to have tenants there. But again, if you're in a non-rent controlled area and you've got this person who's either creating a nuisance, and of course that would be immediately reacted to, like the person with the fire, or you have a situation where you have a malcontent, these are the ones that you want to really take a look at the inventory of your buildings and the quality of the tenants that you have. And while the getting's good, it's time. But once again, 9 o'clock in the morning, Long Beach Convention Center. I hope to see everybody out there. And
except the malcontents. You don't want them there.
No malcontents. That's what I have to say about that.
Okay.
So let's move on, young sir.
Yes, sir. Okay, Dennis, we have, every time we get an eviction at Parkside, we give it to you because you do what you do extremely well. Now, as you know, we have an eviction pending at, let's call it Main Street in Los Angeles. And the tenant hasn't been paying his rent, and we served the 3-day notices. Lo and behold, Dennis, here we are. The landlord has paid thousands of dollars in legal fees. The tenant is demanding a jury trial. The tenant hired the Shriver lawyers to represent...
No, didn't actually hire them.
Okay. The tenant retained the Shriver lawyers to represent him. The tenant is not paying anything. The landlord is losing months and months of rent. On top of that, he's making repairs, which don't necessarily need to be made, but part of the complaint is that the unit is uninhabitable. Dennis, the landlord is asking himself, is the risk worth the reward? Now, we talked about this in detail, but here's the reality. The client, the owner of the property, is behind the 8 ball for thousands of dollars in legal fees. And the other side is, I'm not paying any rent. I haven't paid rent for the last 3 months. My apartment's getting fixed up. I'm on Easy Street. Your response to that, please.
What else does the landlord have in their arsenal to solve a problem? The landlord has a problem. They have a tenant who they rented to, they took care of the premises, never got a complaint, and now the tenant stops paying rent. There's really only one avenue. Obviously the landlord and I'm sure you did as your services, walked over to the tenant, hey, you haven't paid your rent, can you pay me? You made efforts before you contacted my firm, and of course, it fell on deaf ears. Maybe the tenant didn't have the money. Maybe the tenant just decided that this week it was more important to buy himself a leather jacket than it was to pay his rent. Who knows what the issues are? But the reality is you did the only thing you could do, which is to hire a law firm. Now, in a very, very small percentage of cases, they're going to get a free attorney and they're going to ask for a jury trial. In most cases, that's not what happens. In most cases...
Excuse me, how poor do you have to be to get a free attorney? Do you have to show them that you can't afford it?
You show them nothing, you ask for a free attorney, and under the laws of our wonderful state, they get a free attorney to defend themselves in an unlawful attainder, which is basically being paid by the landlord's tax dollars.
So Donald Trump can go to the Shriver Project lawyer and say, I need a lawyer. And
and he'll be appointed a lawyer. And they'll ask for a jury trial, which is what they do in every single case. This is the absurdity with the laws in this state, but then again, don't get me started on this.
Please,
but literally,
okay,
but I'm going to finish your question. The issue is, so does the risk outweigh the reward? And the answer is, what's left? They don't want to pay the rent. They don't want to move. They're asking for a jury trial. Guess what?
This is what's left.
Huh?
This is what's left. I'm showing the word.
You're putting it to the mic.
Oh,
There's
okay.
the camera
Oh,
over there.
Okay.
Can you imagine?
I'm showing the word settlement now.
We have reached out.
I'm just trying to enlighten our listeners. When they call you and they say, I have a problem with a tenant, okay, is there a gap to be filled between filing an eviction and working things out? Talk about that, please.
I think I just did. I said prior to hiring a
No, you
law
said
firm.
the landlord goes up to the tenant
Right.
and tries to work things out. What I'm asking you, kind sir, is what actions on your part will you take to contact this tenant and say, look, you don't want to go to court, we don't want to go to court, whatever words you want to put in your own mouth to settle this matter, talk to me about settlement. Talk to me about it.
Okay. The issue is, in these types of situations, my firm doesn't reach out to the other side. Once the landlord comes to us, the landlord has attempted settlement, and there's nothing further for us to do. I believe in a situation where if you're going to try to get a resolution, you do a resolution through a position of strength.
Okay.
The position of strength is that you file the lawsuit, because otherwise you could be dealing like with the leader of North Korea, which just tries to string every president down the line with talk, but then in the end does nothing. You need to start the process. Now, is it going to turn into a jury trial? No, but you need to start the process, and if the matter settles. In your case, for example, and I don't know that this podcast has to just deal with the your particular case.
I think the questions that I'm asking are broadly relevant.
But in your case, we reached out to the other side at your request. We've sent them letters. We've made overtures to them, and the response has been from the Shriver has been absolutely zero. They have not responded to our request to try to settle the matter, including all you're asking for. Believe it or not for them to even move. All they're asking for is for the tenant to pay the rent.
Okay.
And they're saying no to that. So you know what? There's no other avenue that you have except to have us go forward with this case. And we're successful in jury trials. So I view that this person's going to have an eviction report on his record. He's going to be responsible for thousands of dollars worth of rent, and we chase these people. And we chase them very well in terms of collecting on these debts, because we do have a major collection department in my law firm here. And I can't tell you how much we actually collect on tenants who skip out. So he's going to have an eviction on his record. He's going to have a major judgment. But this is what the Shriver Project is doing, is that instead of trying to settle the matter as they should be, they're not even responding or giving a counteroffer to our what I think to be even a most generous offer, since you've spent money with the law firm. You're not even asking for your attorney's fees back.
Dennis, tell our listeners, we've been using the word Shriver Project back and forth. Tell our listeners, what is the Shriver Project?
That's an act by the state of California which funds different law groups to represent tenants at no charge, and they are instructed to ask for a jury trial in every single eviction case. Now, I could understand where the government will appoint a free attorney when a person's liberty is at jeopardy, where they could be put into jail or even something worse than that, a capital offense. But I don't see where tax dollars have to be spent with regard to appointing free attorneys to represent tenants. Why don't they appoint free attorneys to represent landlords? But of course that would never happen. So we're in a situation, a state that I think has money to burn on certain things, and that's where we stand right now. So it's a very, very unfair situation, and to the chagrin of the landlord community.
Okay, Dennis. So the landlords out there should know that there's a reality to filing an eviction, and the reality is that any tenant, rich or poor, could go to an organization like the Shriver Project and for $0 be represented, demand a jury trial, and the landlord could theoretically be out, not theoretically, they will be out thousands of dollars in legal fees, even if, Dennis, even if they get the back rent owed that is due the landlord.
And this is the situation that we find ourselves in.
Okay.
But the landlords need to put up the fight. They need to go forward with these types of cases when there's no movement, and they need to show the other side that, you know what, you forced this matter to go to trial. You knew you didn't have a good case, and now what you've done is you put a permanent record out there for every landlord to see that anytime this person is going to attempt to lease a unit, that it's going to be on his record. And that's the reality of the situation. So I think landlords also need to hold out that the records not be sealed so that these guys don't just move from apartment to apartment, which is what I'm seeing. The record's sealed so that no one knows that they've been evicted before. It won't show up on an eviction report. And then we're dealt with seeing the same person in the next unit right down the block.
Who determines if the record is sealed?
Generally, under California law, the record is automatically sealed if the matter doesn't have a judgment within the first 60 days. It's an insanity law. However, the landlord's attorney can petition the court once they win the case to then unseal the record so that everyone will know that the person's been evicted. And we threaten that in every single case, that we're going to go back in there and make a motion to unseal the record if we win this case. So we're trying to put some ammunition back towards the attorney that, hey, settle this case because it's not going to be a sealed record.
So you're telling me that from the date that the eviction is filed, if there is no judgment entered within 60 days, the record is automatically sealed?
Right. So you're encouraging people to file delay tactic motions, to ask for jury trials. This is all part of the scheme of the legislature and our wonderful governor, whose name I will not mention, to foster tenants doing bad to landlords.
Okay. Okay, Dennis, let's move on. I want to ask you a question about the word possession, because when people think about a unit, they think that the tenant on the lease is the person in possession of the unit. Now, if you have John Smith on the lease and you do your annual property inspection and you realize that Jane Doe is now occupying the unit, who is in legal possession of that unit?
Obviously, Jane Doe.
But she's not on the lease, Mr. Landlord.
But but you're not talking about who's a party to the lease. You're talking about who's in possession with regard.
Legal possession.
They're in legal possession. They're there.
Okay, so Jane Doe is not on the lease, never paid a dime in rent, and she is. Help me with the language here. She's a lawful tenant?
No, she's not a lawful tenant. She's not a tenant at all. She's never paid any rent, so she's not a tenant.
Who is she?
But she was invited in by the lawful tenant, so she is in possession. I don't know whether you want to call it legal possession. She is in physical possession of the unit. In order to have her move out, you have to go through a legal action.
But who to whom are you suing for possession? The John Smith or Jane Doe?
You could do both. Number one, if if there's a rental agreement, then I'm going to.
There is, and it says John Smith.
Right, if there's a rental agreement, then whether John Smith is there or not there, if he left Jane there, then I would be serving a notice to perform or quit in the name of the tenant, John
Smith.
And then telling him that he's got 3 days to get rid of Jane, that Jane must vacate the unit. If Jane does not, then I'm going to bring a lawsuit in the name of John to vacate, to evict you and all others in possession of the premises. But then you get the curious ones where, for example, and this comes up a lot, where a tenant brings in another person, that tenant does leave, there either is no rental agreement or the tenant didn't exactly leave, the tenant died, and they left this stranger in possession. So in that kind of a situation, we still have to bring forth an eviction. You just can't go over there and use self-help in the state of California. So you have to go over and file an eviction. We call this an illegal subtenant, where we'll serve that person with a 3-day notice that the person who allowed you to come in is no longer in possession of the unit. Therefore, you have no legal possession of the unit, and therefore we bring forth an eviction in the name of Jane as opposed to the original tenant.
Unless, of course, and correct me if I'm wrong, Jane says, you know what, you got me, here's my bag, I'm out of here. And she voluntarily, and she physically walks out. She then, and correct me if I'm wrong again, because I come here for with many questions. Then, if Jane takes her suitcase, in my day we used to call it a valise, but it's morphed into a suitcase. If she takes her suitcase and says, you know what, Mr. Landlord, you got me, I'm not on the lease, I was just here by the invitation of John Smith, I'm out of here, she walks out. At that point in time, who is in possession of the property?
At that point in time, the landlord is, and I would recommend that the landlord immediately change the locks on that place.
Change the locks, okay. Let's, again, Dan, do you know what a straw man is?
I know the concept.
Okay. Do you find in your business where you have landlords saying to you something like this, you know, I rented my unit out to John Smith, and 3 months later, and his credit was great, he was an attorney, he made a lot of money, impeccable credit record. 3 months later, we find that Jane Doe is living there, probably because she didn't have good credit, and probably because John Smith knew that we did not accept co-signers. So he was the straw man, he was the front man, and now Jane Doe is living there. Same answer to that question?
Same answer. I would serve a 3-day notice to perform or quit to the person who actually applied and signed the rental agreement that there's an unauthorized person in possession. And at the end of the 3rd day, if that unauthorized person is still in possession, you bring forth an unlawful detainer action to evict everyone from the unit.
Mm-hmm.
Now, if that person signed a lease, people think that once you serve that 3-day notice and the tenant's evicted, that that's it, the lease is over. Well, the lease is over, the lease is forfeited, but that tenant who signed the rental agreement is still liable for the rent until the end of the lease term. So if it took the landlord 3 more months to find another tenant after the eviction, that original tenant is liable for that and can be sued for that.
Okay, so you are you're now chasing him for money, basically.
You chase for money.
Okay. When you evict somebody, Dennis, do your court documents ask for money, possession, or both?
Both.
Both, always?
Always. In an unlawful detainer, we're seeking all the rent owed, plus we're seeking the reasonable rental value of the property. That's the period of time after the notice expired. So for example, if I serve a 3-day notice for the April's rent, and now we're into May 5th, so we're seeking the daily rent for every day from May 1st forward in time. The daily rent is the rent divided by 30. So if the rent's
per diem.
Per diem. So if the rent's $1,000 a month, it would be $33.33 per day that we'd be seeking for every day in May and further into June.
Let's say that the landlord's last rent increase was May the 1st of 2017. He's in the middle of an eviction. Oh, it's May the 1st, 2018. Are you allowed to raise the market rent on a unit that is in the middle of an eviction and therefore use those dollars as the basis for the monies that you want to collect.
No, it's when you started the case, it was the rent at that time.
Okay, so you can't do that. Dennis, we have a building where, as you know, marijuana is legal and now in the state of California.
I've heard that.
Yeah, right, and I see some over there on your desk. But no, that was a joke, folks. If one tenant is claiming in unit number 1 that the tenant in unit number 2 is smoking pot, the tenant in unit number 2 smoking pot is not doing anything illegal. So what is a landlord to do when tenant number 1 is complaining about pot smoking tenant number 2?
I would respond by saying it's not illegal under any California law to watch TV, correct?
Correct.
But if you have the TV on loud in the middle of the night, that could be grounds for a nuisance.
This guy is smoking pot, and I'm giving you just an example. At 3 o'clock in the afternoon, he's tenant number 2, and tenant number 1 works from home, and suddenly he's smelling marijuana.
So he is being bothered by the actions of the other tenant, correct?
Keep going, I'm listening.
Okay, so just like with my thought of dealing with the example of a television, where a television is not illegal, but if you're playing it loud late into the evening, that can be a nuisance to other tenants. The same thing is true of marijuana smoking or cigarette smoking. If the person is smoking in their unit and that smoke is bothering other tenants, that could constitute a nuisance, whether it's legal to smoke or not, or even if it's cigarettes.
But you see, Judge Dennis, I have a prescription from my doctor saying that I need to smoke marijuana because of my arthritis.
And God bless you, smoke it as much as you want, but you don't have the right to smoke it in a fashion where other tenants are being bothered.
Really? So again, Judge Dennis, my medical condition and my medical requirements do not supersede the laws of nuisance.
No, of course not. While the landlord has to allow for a reasonable accommodation when someone has a disability, and let's pretend you needed to smoke marijuana because of your arthritis, and the way I've seen you walk, quite frankly, I think
Thank
you
you
do.
very much. I appreciate that. He always manages to dig one in, folks.
I got it, you know. Well, you had the marijuana
That's
on my
right,
desk.
that's right.
So, did we forget?
We reap what we sow.
But notwithstanding your disability, it has to be a reasonable accommodation. If I've got tenants in the building complaining like, oh my God, I feel like I'm walking through a smoke tunnel here,
Sure.
and it's affecting my health and also my kid's health,
Right.
I don't want my kid to be smelling this, then, and we all know smoke is a carcinogen, so on that basis, you can make a ruling, a rule to the tenant saying that, look, if you want to smoke, I'll give you a reasonable accommodation. Maybe what you need to do is to go out by the dumpster and smoke, or maybe what you need to do is smoke in a rear room which nobody else is going to be affected. But you can't be smoking, notwithstanding your disability or the legal right just to recreational smoking of marijuana or cigarettes, that it's bothering other people in my building.
Okay, Dennis, I think that we are out of time here, but once again, I want to remind our podcast listeners that Dennis will be at the Long Beach Convention Center on May the 15th, 9 a.m. He will be talking about the Costa-Hawkins law. He will be talking about vacancy decontrol, and he'll be giving away a whole bunch of stuff. Dennis, as always, tell our listeners how to reach you.
Well, first of all, I always enjoy doing the podcast with you. What a guy.
Thank you.
What a man.
Thank you.
But if anybody wants to reach me, I've got a toll-free number. It's right up there. It's 1-800-77-EVICT. Or you can go to my website, which is evict123.com. We actually started something new on the website. We now have a chat feature. So if you want to chat with your attorney on your existing case.
I've actually done this, folks. I've gone on the chat room about 4:30 in the morning, and he was there. This man is a medical marvel. He does not sleep.
I do get to the office early. So that's actually at evict123.com/chat, CHAT2, the number 2. And if you have an existing case, you can chat, or of course you can just call the office at our toll-free number. We are open on Saturdays from 9 to 1. And again, hit our website at evict123.com. All of our forms, our podcasts are there. And I think you'll find so much information, and it's all at no charge.
And I'm Zachary Lawrence of Parkside Property Management. Maybe someday my telephone number could be on this big screen. We'll talk about it.
As soon as you pay for the screen.
Thank you. I knew that. I can't win, folks. See you next time. Take care. Bye.
Bye-bye, everybody.